My name is David Hodson. I'm a solicitor, mediator and arbitrator at the International Family Law Group in Covent Garden in central London. Most of my work has an international element as a family lawyer, dealing with international disputes with many countries around the world. This web seminar is about the implications of the Brexit vote, the referendum vote, on family law in England and Wales, family law in the United Kingdom, and family law wider as far as the EU is concerned, and where some of the issues may arise over the next 2 or 3 years as the UK departs from the European Union. Perhaps to start with a few thoughts of reflection. Fairly early on the morning of 24th of June 2016, family law woke up, came downstairs, turned on the television, looked at the results coming in, saw the percentages at the bottom of the television screen, shrugged its shoulders and thought, well, that was the percentages expected, and went off to make a cup of coffee. But then something heard on the television screen caused family law to pause and to look back. And yes, it was the percentages, but the percentages were in completely the opposite direction to that which most, perhaps almost all, had expected, including those who had voted to leave. It was perhaps the biggest decision by the democracy of the United Kingdom for very many decades, perhaps even longer. And it will have implications as we now know, this being recorded in December 2016, 6 months on, implications for the political system. We have a new Prime Minister, we have a new Cabinet, we have new ministers conducting these various issues. But it has implications for the whole of the legal profession, for the justice system, and we now have several government inquiries looking at how the justice system should cope with the implications of Brexit. In fact, as it happens for family law, it's a moderately simple arrangement. There's not too many of the intermeshing that occurs in some other areas of law. Some of our colleagues in different disciplines in law have got a much more mixed, far more mingled arrangements of their law with the European Union than we have in family law. What's one of the first and most important issues to raise for us as practicing solicitors, barristers, judges looking at this? And that is the whole question of valuations. Those of us doing financial elements on divorce have got to say to ourselves time and time again, be careful, what is the valuation? And we have seen in the days leading up to the referendum, crucially in the days after the referendum, then over the summer 2016, running through into the autumn and winter of 2016, a colossal number of changes in valuations. Valuations of real properties, certain parts of central London, the home counties, southeast of England, and across the England and Wales and the United Kingdom. A lot of changes in real property values. Some have gone up, some have stabilised, and some have gone up an awful lot, and some have fallen. Then there are the property, the other markets, the investments that people will have in pension funds, in other stocks and shares. They will have gone up and down significantly as well. Some businesses will have done very well out of the Brexit vote. Some will have done very badly. Some of these will have done well initially and may then actually fall away over the coming months. So crucially, I would be saying to all solicitors, barristers operating in finance work in the family law arena, always double check your valuations. Should this be changed? If it was a pre-June 2016 valuation, almost certainly you'll want an up-to-date one. But I'd be saying even if you've got a July, August, September valuation, double check and say, is this an arena where there may be a lot of changes? So be careful about that. The next practical area where a lot of questions are being asked is the transitional provisions. At the moment, it is not anticipated there will be any transitional provisions before we actually leave the European Union. There may be some transitional arrangements after that date, but it's not likely that there will be any changes before that date. Certainly none of these have been referred to. and I'll come on to one slight variation on that. That's the amendment to the Brussels regulation. But certainly as far as national UK, England and Wales law, no variations are expected, no changes. However, I do wonder how, as the months and then the year or so goes by, getting closer to the date we leave the European Union, where there are deeply unpopular laws that have come from the European Union and laws that are almost certainly not going to be enforced in English law, just not enforced at all, after we leave the European Union, whether or not that actually will be less regarded, almost disregarded by the judges. I'm certainly not suggesting for a moment they will not operate according to the full law of England and Wales at any particular time. But I do remember when we had the Children Act. The Children Act 1989 came into force. I have vague memory about October 1991. Certainly there was a 2-year run-in. That as we got closer to that date, judges and lawyers increasingly operated according to the new law rather than the old law. We knew the law that was going to come and we operated accordingly. And so I just question whether or not that may actually apply. Can I turn now to actually the arrangements that we have got within our national law where EU law does apply? Where is it that we are having these discussions about what the new laws should be? And I think it comes into 3 particular categories. First of all, it is divorce, and I'd link that in with the maintenance regulation. Secondly, it is private children matters, and thirdly, public children matters. And the last 2 I'm only going to speak briefly about. So can I start with the area of divorce and related to that the maintenance regulation, because divorce is the primary area where there has been a big impact. Many solicitors, barristers, maybe even some judges are not aware that when somebody is issuing a divorce petition, the jurisdiction for a divorce petition is based upon EU law. The Brussels regulation, Brussels II, in force March 2000, came and amended, and in it, Article 3, you see all the grounds for jurisdiction. And the grounds for jurisdiction in Article 3 of Brussels II applies across the whole of the member states of the European Union. It is identical. And it's primarily based on habitual residence with, in one circumstance, a sole domicile or the joint domicile of both parties. It is right across the whole of the European Union. And if Article 3 is not available, there is sole domicile that is available if no other EU member state has jurisdiction. So in this particular way, there is identical divorce jurisdiction across the whole EU. So what will happen when we leave the European Union? This is still December 2016 being debated. In fact, it's one of the areas where there's been less progress in the debate. Some are saying we simply adopt that and put it into our national law. Some are saying we go back to the old law, which was 12 months habitual residence plus sole domicile, or alternatively sole domicile. I, for myself, would doubt we will go that far back. We have got used to working in the last 15 years with the menu of jurisdictional possibilities. I would have thought it's probably likely that once we leave the European Union, some form of Article 3 will be put into our national law so that we know the grounds for jurisdiction in any divorce petition in the future. So that will need discussion, and I would have thought those discussions will take place over the spring, very early summer of 2017, so that by summer 2017 we would hopefully have within the family justice system in England and Wales, the profession here, we will have worked out what it is that we should be having for the future. So that's the divorce jurisdiction. That, I think, is less problematical. I think the biggest problem that arises throughout this is what do we do when there are more than one member state having the basis of divorce proceedings? What happens if it can be proceedings in both England and in France? What happens at the moment? Well, it's very simply who is the first to lodge proceedings, known by the Latin phrase lis pendens. Who is the first to lodge? Whoever is first to lodge, and that country does have jurisdiction, then the proceedings will actually be in that country. And that has been a deeply unpopular law. It reduces the race to court, And some of the problems have arisen have, for example, no one ever mediates now until they've raced to court and they've won, and then the other party says, why should I mediate with you because of all the difficulties you've created, the tactical manoeuvrings in issuing first. Secondly, and even worse, who would then engage in discussions about the future of the marriage reconciliation? If they're going to say, well, look, my dear spouse, our marriage is in difficulties, can we have a discussion about marriage reconciliation? The other may say, well, maybe yes, but if it doesn't go well, they're going to issue proceedings. I ought to issue first in the country that is preferable to me. Thirdly, any agreements that have been reached about where the proceedings should take place have no validity whatsoever. Fourth, it really favours the party who's got the money to go to a lawyer who's going to engage in forum inquiries to find out the best jurisdiction. I hold my hands up and say I am one of those lawyers. It's a significant amount of the work that we do is the forum disputes, forum shopping and finding the best forum for a client. So this is something for the person who's the wealthier spouse, moreover the spouse who's going to break up the relationship. So for all these reasons, lis pendens has been very deeply unpopular. But on the other side, it does produce certainty. It may be a very arbitrary certainty, but it does produce certainty and some predictability. And that's why some in England and Wales are arguing that we should introduce it into national law and then in some way reciprocate with all the other EU countries. This is going to be probably the biggest argument that we will have in family law over the next coming 6 months or so through until the summer of 2017, because by then we really need to know where we will be going. Should we go back to where we have the position, for instance, for the rest of the world? Well, if there's a dispute between England, Australia, South Africa, Russia, places like that, America, many countries around the world, everywhere in fact outside the European Union, it is forum non-convenience. It is where is the country with the closest connection. And often one stands back from a case and says, yes, it's more advantageous to my client to be in this country, but in reality this is a, whatever the other country may be, family. And there's been a number of case law decisions where the court judges have stood back and said, yes, this is eminently a Florida case, or this is a French family, and the proceedings should be in that country. Those who argue that we should adopt into English law the race to court say this will produce a deluge of matters coming before the courts. I don't think that will happen. At the moment we have a huge number of international families from around the world outside the European Union here in England and Wales, and the courts are not flooded, to use the analogy that's used, deluged with a huge number of forum disputes, forum non-convenient disputes. It's a far better system. It's fairer. It's a tailor-made, the discretionary tailor-made to our particular system of law. And so I certainly, for one, would be strongly arguing that we should revert to the forum non-convenience so the whole world had just one test. If it's proceedings in England and any other country around the world, including the European Union, where is the closest connection? So the big issue, I think, going forward will be the forum test between us and the European Union. The third element on divorce is a recognition of foreign divorces. At the moment, that's automatic around the European Union. I myself do not think this is likely to be an issue. It's a long time since I've come across a situation where in a regularly granted divorce through the courts of another country with which England does a lot of family law traffic around the world, EU or otherwise, where there's been any difficulty in recognising a foreign divorce, and vice versa. I have come across very rarely cases where other countries with which we work and operate regularly have refused to recognise the divorce granted by the English family courts. I don't think that will be a particular problem, and we don't need the Brussels regulation. We can revert to our own national law, and that invariably is good enough. The other area that's linked to this is the maintenance regulation. This was, as was said by the FLBA representatives at a meeting held by the House of Commons Justice Committee in mid-December, a curious piece of legislation. Yes, it's been enforced now for 4 or 5 years or so, but it's been a very uncertain law. We're still getting to grips with some elements of it. Many of us are unhappy that we can't make maintenance, which means needs-based orders based on sole domicile. There is a restriction on the powers that we've got. There's a 2-track procedure around the European Union for enforcement, so that if an order is made from England, Wales, the UK, or indeed from Denmark, it has to go through a longer process because each of these countries applies our own local law than those countries that apply their applicable law and then wish to enforce it abroad, including in this country. There are some real problems with the maintenance regulation, and I just don't think we need to have it in force, for the primary reason that we have a very good substitute. That substitute is the Hague 2007 Child Support Maintenance Convention. That was drafted at the same time as the as the EU Maintenance Regulation. It's got similar concepts. It doesn't have the applicable law problems. It doesn't have the sole domicile problem. It does allow direct enforcement to go through. The United States has signed up and is fully on board January 2017. A number of other countries are going to increasingly come on board. The European Union is fully on board through signing up en masse. So I would say we've got our own ready-made substitute to actually put in within that. There it comes really the end of the private non-children matters. There aren't really too many other issues. We've got elements such as service of papers, taking of evidence, legal aid, but again the Hague provides a backdrop to it. England and Wales, the United Kingdom, is a massive international family law centre. There are so many of the big international family law cases around the world being dealt with through England because of an England connection. Of course, as everyone says, we are a generous jurisdiction. We make substantial redistribution orders. We are therefore attractive to many spouses seeking a good settlement. We don't need to have many of the EU laws, and to try and embody them into English law in some way at a particular date means we could get out of kilter with it. So perhaps the answer is to have a national law, but try to reflect in some ways some of the elements of the EU law with which we've been working. Turning now to children issues, these are of two forms. First of all, private, and secondly, public law. I start with private. The EU law that applies here is the Brussels Regulation, now amended in 2003, enforced 2005. This builds, of course, on the Hague 1980 Child Abduction Convention. That 1980 convention is one of the most successful of all international laws. Many countries around the world sign up. Some are more diligent, punctual, efficient than others, but by and large, through the Hague network of judges, which works very successfully, operates between countries, there is a relatively good success rate in returning a child that has been abducted by parents, family members from one country to another. A return order is made. There are undertakings for safe harbour orders and safeties like that. The Brussels regulation has built on that, and so actually it is a refined element of it. But England and Wales, and I can only speak about England and Wales, but I think the rest of the United Kingdom would naturally follow with this. We are some of the leading countries, certainly around Europe, around the world, in our diligence in dealing with child abduction matters. We are very fast. We're faster than almost all of the other EU countries, maybe all, but there's a couple of other countries such as Germany that are also fairly fast as well. But within the whole of the European Union, we are one of the fastest. We are one of the most diligent. We are one of the most careful at listening to the voice of the child in our own particular way and securing the return of the child. So although now in the last 6 months the European Union says we're going to amend the Brussels regulation in relation to child abduction and other children issues, and that's what is known as Brussels regulation recast, Brussels II recast being effectively a newer version of it. Although it includes elements of a newer timetable, things like that, by and large England is well ahead of the game anyway. The United Kingdom government over autumn of 2016 has agreed to sign up to the Brussels regulation recast, presuming it comes into force before we leave the European Union. If it's after we leave the European Union, then it's all part of the discussions about what we actually have within it. So as far as child abduction is concerned, yes, many of the proposals now made to improve the Brussels regulation are fine, but England, Wales, United Kingdom is going there in any event. Another area is the recognition of children orders around Europe. Just similar to the Brussels regulation for divorce orders are automatically recognised, so it is with children orders, return orders, access orders, contact orders, parental responsibility orders, as they may be differently described in different places in the EU laws and around the European Union. It is automatic. But we now have the Hague 1996 Child Protection Convention signed up to, entered into by many countries around the world. The UK only signed up when the EU joined en masse. Many of us were very frustrated that it had been so long before we could sign up. That really fills the gap. That is, in many ways, a significant part of what the Brussels regulation does for the recognition of children orders around Europe. I'm certainly not going to say it is exactly the same. It isn't is good in certain ways as the Brussels regulation, but when one looks at saying, okay, we've got the Hague to 1996 already in place, do we need therefore to have all the difficulties, all the complications of bringing in the parts of Brussels II that relate to private children, recognition of children orders? And I would be saying England's a global power in the world, let's just follow the Hague Conventions. So those are the primary two areas. There's issues such as listening to the voice of the child, where England listens, but perhaps in a different way to other European Union countries. And then thirdly and last of all, in this overview, I turn to public law, children matters. And here there is a distinctive problem, a distinctive aspect arising primarily with local authorities, primarily with a few countries in Eastern Europe, where there are many children who from in England, where the local authorities want to have the power to continue to transfer proceedings back to the countries from which the child may originally have come. This is an area beyond the expertise of most of us as family lawyers. It's often not pure private work. The local authority is involved, and there's a few local authority solicitors working in the areas where there's a significant number of international families where adoption and care proceedings will be important. And I have heard it said and argued very well by public law children lawyers that we need some elements of the Brussels regulation to stay in national law so that we can return children in particular circumstances. I see the force in it. I don't think it flows through into other areas, but I can see the force in it. Maybe the answer is to have some transitional arrangement so that if the free movement of labour comes to an end as anticipated on Brexit, perhaps there could be a 3-year, 5-year period, almost a transit period, to actually allow these local authorities to still have these powers. I wouldn't profess to say I'm an expert on these issues, but that's one of the ways that we could actually bridge that gap. I certainly see the strength of the arguments in the public law field. And then, in full conclusion, I'd like to stand back and say, where are we now going? Where is the law of England and Wales looking forward to the future? And it's very much my thoughts, very much my vision, very much my hope, that as a consequence, as we now discover it, a consequence of the referendum vote, that England and Wales, and I keep referring to England and Wales, I certainly don't intend to leave Scotland and Northern Ireland, the rest of the United Kingdom out of this, but I view myself as an England and Wales family lawyer based in this jurisdiction. England and Wales, the United Kingdom, should fully assume our role as a world leader, not the world leader, of course, a world leader in family law matters. So many of the laws that we have introduced over the last 10-15 years have been incorporated in other laws around the world, borrowed in different ways. Our Children Act, going back to 1989. In the early 1990s, our Form E, our FDR procedure, certain other elements of our ancillary relief financial provision procedure on divorce has been borrowed. We've innovated in fundamental areas such as forced marriage, FGM and things like that, so important in certain distinctive aspects. And we have worked jolly hard in so many ways as a developer, an innovator, to find new ways of working. We have family arbitration, so do some other countries, but we have promoted it in different ways. Mediation came to this country primarily from North America, but mediation has been developed in the family law sphere here. Early neutral evaluation. We have a real specialist group of solicitors, barristers, judges used to dealing with international families. We're innovating, we're trying to find ways that we could do this. And there is some feeling that perhaps in the last 5-10 years or so, being part of the European Union, where we've not been able to enter into agreements with any other country unless the EU gave permission for us to do so en masse, we have in fact been held back, and certainly I'd be open and say that is my view of how I have perceived it. And I would like to think that in the future we will still have very close relationship with the European Union. We're bound to. There will be so many from the European Union living here, so many from England, Wales, the UK will be continuing to live and work in the European Union. There's bound to, we want there to be close dialogue, close working together, there has to be. But more than that, England and Wales is a global world leader. We're a centre for innovation and development of new ideas, new laws, new ways of working in family law. And perhaps the result of the referendum, the Brexit vote, is that now we'll have a far greater opportunity to develop that, to move on, and to play a role with other countries around the world, developing countries, economically very wealthy countries, but may not have such a developed family law as we have over the last few decades. And we can share with these countries, enter into agreements with these countries, bilateral agreements or whatever, that is simply impossible were we to continue within the European Union. And therefore, in this way, England and Wales, the United Kingdom, will fully assume our role as a global leader, helping to develop the laws of the world, around the world, countries around the world, helping the very many international families travelling the world on work for reasons of movement of labour, for personal reasons, marriages, relationships with somebody from another country, another part of the world. So many of the international families, and there will be a continued increase. And it is our responsibility to try and find laws that will help them, and laws that will help them across the world, and not just linked here within the European Union. Certainly Brexit is a challenge, but it's also an opportunity. And I'd like to think the English family law profession will seize them opportunities and adopt the challenges and go forth from that. It will be interesting times. This video will be updated every 4 to 6 months or so as it happens. My firm will give developments on the International Family Law Group website whenever there's any material developments. It will be interesting times for us as family lawyers. It will be interesting times for international family law. Thank you very much indeed.